And you see that blue part where it says, should the plaintiff fail to sign a release? And there was a pretty contentious hearing where I said, I'm not signing the release because the release does not mirror the stipulation. But should I fail to sign it within 10 days of the order, it shall be enforceable as if I had executed the release. Essentially, Judge Emily Peacock ordered me to sign something against my will that I had no desire to have. Then they came back on the back end when I sued them for what was called fraud in the inducement and argued I agreed to voluntarily sign or release the parties, which is this is what we're coming to on Monday, is their motion to supposedly dismiss the action for those reasons, and that Mr. Doss, they actually even try to get sanctions on me, which that's not going to go any goddamn where, because Brett, you want to tell them the part that we learned about for them to be able to be sanctions, what has to happen for an action to be frivolous? And we do the case law thing, and one thing I'm going to tell everybody about AI, do not use AI and just run with it.
No, you're going to waste your time. Then you go to the case site and it's like it doesn't even exist. It's called the phantom case site.
But clearly, this release contains, just facially, the release contains more language than the stipulation. So what we're looking at on the one that I filed, we saw the language about voluntary, which if their argument is I did it voluntarily, the order wouldn't exist. Whenever you settle an action as a litigant, the prevailing party under Florida law has to do what's called a disposition form. And essentially saying, okay, I have agreed to this particular settlement. What does not exist in case 2018 CA 3553 is me executing a disposition. When it came back before Judge Peacock, and her release, by the way, includes parties to include the nation's largest insurer. And this is their anything. And here's the word, any kind whatsoever litigation for something that has nothing to do with Shonda and Linda Tucker. He never filed an appearance on behalf of the United States government. And to this day, I don't know if he was ever authorized to operate on their behalf. And State Farm, which not just State Farm on behalf of the Tuckers, because we all know we buy insurance. Our insurance companies agree to accept their insured's liability up to the limits of their liability coverage. But of course, we do know that representation in these actions is typically unlimited, I believe. But State Farm was never an independent tortfeasor in this action. So my issue with Shonda and Linda Tucker is separate from State Farm. Now, I'm not an attorney. I'm not even a friend, not that they're an enemy of the Tuckers. But if I were related to the Tuckers, I'd be wondering why somebody on their behalf hasn't said, hey, State Farm may have operated in bad faith, because in Florida, insurance companies have a duty to represent the interests of their insured above their own interest. And as we go down on here, the first thing you're going to see is the word, I had to say, I hereby declare that the terms of this settlement and release have been completely read and are fully understood and voluntarily accepted. I don't know how we conflate volunteerism with Mr. Doss go sign that document, which is something that would go back to the argument. And as you can see, I signed it under duress, which would go back to the argument as to whether Judge Peacock overstepped her scope and authority by rewriting essentially the stipulation. And did Judge Peacock ever have jurisdiction over the other parties who were never a part of the litigation and for matters that were not pled? And then the question comes, who's going to check